Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Hi there, just me today. Today I'm going to bring you another installment of our multi-part series of The Queen and Barton. If you want to go and hear what me and Zach had to say about the case, head on over to the first episode in the series. I'm going to throw a content warning at the top of this one. This is very hard to hear, and it's very difficult subject matter, and it involves the sexual assault and death of an Indigenous woman. If that's not the right content for you, that's okay. Head on over to a different episode. I hope you enjoy. The reasons of Chief Justice Wagner and Justices Abella and Karakatsanis were delivered by Justices Abella and Karakatsanis. Section 276 of the Criminal Code was enacted to preserve the fairness and truth-seeking functions of the trial, as well as the dignity of victims of sexual assault. At the heart of the provision is the prohibition of evidence of prior sexual activity, evidence which could lead the trier of fact to reason, based on this sexual history, that the complainant would have been more likely to consent to the sexual activity in question, or is less worthy of belief in general. These two prohibited inferences have come to be known as the twin myths, whose insidious harm to the goals of truth and of dignity has long been recognized by courts. In addition to prohibiting twin myths reasoning, Section 276 makes evidence of a complainant's prior sexual activity inadmissible unless the accused complies with the criteria and procedures set out in Sections 276, 276.1, and 276.2. In this case, the trial judge permitted the accused to lead such evidence without following the procedures required by Section 276, thereby allowing him to make unrestricted references to the deceased's sexual history. He also failed to give the jurors any kind of limiting instruction to advise them that such evidence could not be used to show that the victim was more likely to have consented. All of this was compounded by the fact that the trial judge permitted on dozens of occasions for the deceased to be referred to as native and prostitute, without providing any instruction to guard against potential prejudicial reasoning based on these descriptions. There was thus no filter for the victim's prior sexual history and no specific warning to the jury to avoid drawing prejudicial and stereotypical assumptions about Indigenous women working in the sex trade. This left the jury with an essentially unchallenged version of the accused's interactions with the deceased. This was the narrative's frame in which the victim's conduct was portrayed and the accused's credibility was assessed, creating an image of the deceased that was unfair and would have permeated the whole trial and the jury's deliberations on both murder and manslaughter. To now compartmentalize these significant errors and to suggest that they only partially affected the way the jury assessed the accused's credibility ignores what was at issue in this case. With no protection from the trial judge, either in the form of a Section 276 inquiry or a cautionary instruction to resist the kinds of prejudicial inferences a sexual assault trial involving a female Indigenous sex worker can attract, the jurors were left to draw their own uninstructed conclusions about what happened. The trial judge failed to appreciate that the victim's prior sexual conduct, occupation, and race required the jury to be specifically alerted to the dangers of discriminatory attitudes towards Indigenous women, particularly those working in the sex trade. He provided no specific instructions crafted to confront the operative social and racial biases potentially at work. This rendered the whole trial unfair. Part 1. Background. On June 22, 2011, Cindy Gladue was found dead in Bradley Barton's hotel room. She had bled to death from an 11-centimeter gash inside her vagina. Mr. Barton was arrested and charged with first-degree murder. At trial, the Crown advanced the theory that Mr. Barton had hired Miss Gladue for sex, incapacitated her with alcohol, and intentionally put a sharp object into her, causing the wound that killed her. In the alternative, the Crown argued that he had sexually assaulted her in a manner that could reasonably have been foreseen to cause bodily harm and was therefore guilty of manslaughter. Mr. Barton maintained that all of his interactions with Miss Gladue were consensual. He testified that he and Miss Gladue had agreed on a price the night before, $60 for everything, and that she had willingly returned the second night on the same terms. He testified that on the second night, as on the first, he had thrust his fingers vigorously in and out of her vagina, but had penetrated deeper using more force. He stopped, then saw blood in his hand. Miss Gladue then went to the bathroom and Mr. Barton fell asleep. He found her dead in the morning. He attempted to clean parts of the room, panicked, and left the scene before returning after some time and calling 911. Both before and after being arrested, Mr. Barton made up several false stories regarding what happened. The jury acquitted Mr. Barton of first-degree murder and the included offense of manslaughter. On appeal by the Crown, the Alberta Court of Appeal concluded that the trial judge had made several serious errors that had affected the jury's ability to assess the evidence and correctly apply the law to the facts of the case. It allowed the Crown appeal and ordered a retrial on both first-degree murder and manslaughter. Mr. Barton appealed. We would dismiss the appeal. Section 276 is designed to ensure that the jury does not engage in impermissible and prejudicial reasoning about a victim based on her prior sexual activity. The failure to comply with it caused a cascade of prejudice and errors warranting a new trial on murder as well as manslaughter. It resulted in Mr. Barton's unfiltered testimony going to the jury and infecting the whole trial, and created a significant risk that the jurors would make impermissible inferences based on prejudicial reasoning that would have tainted both their view of Miss Gladue and of their assessment of Mr. Barton's testimony. In our view, these errors would have had material bearing on the acquittals and the concrete reality of this case. Because of the inextricably integrated nature and significance of the errors, we agree with the Alberta Court of Appeal that a new trial is required on the charge of both murder and the included offense of manslaughter. Moreover, we would uphold the Court of Appeal's ruling regarding the jury charge on after-the-fact conduct. The fundamental error in the jury charge on this matter also requires that Mr. Barton be retried on both murder and manslaughter. Part 2. Analysis. It is precisely because evidence of a complainant's previous sexual activity will be highly prejudicial that Parliament made it presumptively inadmissible. Without being properly filtered and restricted by appropriate limiting instructions, such evidence can lead to propensity reasoning based on the twin myths, namely that simply because of previous sexual activity, a victim is both more likely to have consented to the sexual activity at issue and is generally less credible. The majority has accurately and comprehensively summarized the importance and legal history of Section 276. The evidence in this case, predominantly tendered through Mr. Barton's own testimony, included detailed descriptions of Miss Gladue's sexual activity on the night before the events leading to her death. As well, Miss Gladue was described repeatedly by both the Crown and the defense as a native prostitute more than 20 times throughout the trial. Although this evidence clearly fell within the scope of Section 276, the trial judge failed to apply the mandatory admissibility inquiry required by that provision or to give the jury limiting instructions to temper the prejudicial effects of Mr. Barton's testimony. Moreover, the repeated references to the complainant as native girl and native woman created the potential for further prejudice. It was a critical legal error to admit Mr. Barton's testimony without considering its admissibility pursuant to Section 276 and without providing any limiting instructions to the jury. There is no doubt that this evidence had ripple effects that prejudiced other parts of the trial, permitting the jury to engage in dangerous and impermissible inferences about key issues that may well have had a material bearing on the acquittals. The devastatingly prejudicial effects of this error cannot be said to be confined to the included offense of manslaughter, but may also have had a material bearing on the jury's reasoning on the charge of first-degree murder. The prejudicial impact of Mr. Barton's detailed testimony, without either the screening required by Section 276 or any limiting instructions, necessarily infected the whole trial and the entirety of the jury's fact-finding process. The admission of this evidence, in contravention of Section 276, may have tainted the jury's view of the deceased and its assessment of the evidence tendered by the accused about the nature of the sexual activity, including his testimony that he did not use a sharp object. In short, there was a real risk that the profound prejudice caused by the trial judge's error contaminated the jury's broader fact-finding function, including on murder. In our view, it cannot be said that the murder charge was decided merely on a battle of expert evidence as to whether a sharp object was used. Unless otherwise cautioned, juries are entitled to consider all the evidence they heard at trial in their deliberations. The unfiltered admission of Mr. Barton's testimony, which included extensive details of his sexual encounters with Miss Gladue in contravention of Section 276, likely tainted the jury's view of Miss Gladue, and would have been the lens through which the jury assessed what happened. This was especially true since the only other witness to the events was dead. Furthermore, even if the evidence had been properly admitted, the strong possibility that the jury might engage in impermissible twin myths reasoning based on Mr. Barton's description of Miss Gladue's previous sexual activities necessitated a strong limiting instruction. Instead, the trial judge, on a number of occasions, instructed the jury to base its findings of fact on Mr. Barton's version of events. In outlining the offense of sexual assault, for example, the trial judge told the jury to consider whether Miss Gladue had consented to the type of sexual activity described and demonstrated by Mr. Barton in his testimony. Later, the trial judge indicated that there is some evidence that Cindy Gladue consented to the application of some force by Mr. Barton, including sexual activity and the activity described by Mr. Barton in his testimony. The repeated instructions to the jury to consider Mr. Barton's testimony about the events as the basis for further findings of fact amplified the potential for the twin myths reasoning prohibited by Section 276(1). Indeed, the jury's portrait of Miss Gladue was painted almost exclusively through Mr. Barton's testimony, which meant that there was a significant possibility that the jury's entire deliberations would have been based on fundamentally flawed and prohibited legal premises. The potential for prejudicial reasoning was further exacerbated by the repeated description of Miss Gladue as a prostitute and as a native, without any limiting instruction from the trial judge. Based on studies that found that jurors were more likely to convict a defendant accused of raping a woman with a chaste reputation than an identical defendant charged with assaulting a prostitute, this court in Seaboyer expressly warned against the use of the word prostitute, because the use of this term is intrinsically linked to twin myths reasoning and can lead to substantial prejudice in the way the jury assesses the evidence. The undisputed biases against sex trade workers and against Indigenous peoples can be as invasive and elusive as they are corrosive. Indeed, as compellingly explained by the Alberta Court of Appeal in this case, because Miss Gladue was in effect labeled a native prostitute, the jury would believe she was even more likely to have consented to whatever Barton did and was even less worthy of the law's protection. These references introduced a risk that the jury's reasoning might be tainted by conscious or unconscious racial prejudice or reliance on racist stereotypes. To guard against eroding public confidence in juries, it is important to address the concerns expressed by the Ontario Court of Appeal in the Queen and Parks and confirmed by this court in Williams, that specific safeguards are required in jury trials to prevent systemic biases that can affect jury deliberations. As Justice McLaughlin observed in Williams, the evidence of widespread bias against Aboriginal people in the community raises a realistic potential of partiality, which creates the risk that the verdict reflects not the evidence and the law, but juror preconceptions and prejudices. Acknowledging, as this court has for the last 2 decades, that racial prejudice is a social fact not capable of reasonable dispute, it is not an insult to the jury system, it is a wake-up call to trial judges to be acutely attentive to the undisputed reality of pervasive prejudice and to provide the jury instructions required by law. That means that in cases where this reality is relevant, especially in the context of sexual assault, juries need to be carefully instructed on how to approach the evidence with an open mind and not allow their reasoning to be obstructed by subconscious stereotypes. Trial judges have an important role to play in instructing juries so that they can recognize and set aside racial and other biases, including those against Indigenous peoples and sex trade workers. Not only did that not happen here, the opposite occurred. Inflammatory terminology was frequent and was gratuitously used without any corrective intervention by the judge. In summary, the trial judge's failure to apply the requirements in Section 276 created a significant risk that the evidence of Miss Gladoux's prior sexual conduct not only tainted the jury's perception of her character and conduct, but also fundamentally affected the factual foundation upon which their deliberations were based. This error permeated the entire trial and may have had a material bearing on the jury's deliberations, affecting their verdicts for both murder and manslaughter. Given the prejudicial impact of these references and the risk that they would affect the jury's assessment of Miss Gladou and Mr. Barton's credibility, it is difficult to see how it is realistically possible to conclude that their effect was confined to the jury's verdict on manslaughter. The risk of harmful effects on the jury's deliberations on murder would have been no less profound. When a trial with intimately connected issues, such as this one, is riddled with highly prejudicial testimony, it affects the very foundations of a jury's fact-finding function and decision-making. The trial judge's error in permitting evidence of prior sexual activity to be admitted, in clear contravention of Section 276, could reasonably be thought to have had a material bearing on the jury's deliberations as a whole. It was a fundamental error, warranting, on its own, a new trial on both murder and manslaughter. Additional highly prejudicial errors by the trial judge exacerbated the harm created by failing to apply the clear requirement of Section 276, namely the errors in his instructions regarding Mr. Barton's after-the-fact conduct. We agree with the Alberta Court of Appeal that the jury instruction on after-the-fact conduct was confusing and misleading. After-the-fact conduct refers to anything said or done by an accused after the commission of the alleged offense. It is a form of circumstantial evidence, and its use is highly specific to the factual matrix and context of each case. It can be probative of whether the accused was conscious of having committed an offense, and of particular significance in assessing credibility. In his own testimony, Mr. Barton admitted to lying, disposing of evidence, and providing contradictory exculpatory explanations to numerous people after Miss Gladoux's death. It was open to the jury to conclude that additional incriminating after-the-fact conduct evidence came from the hotel video camera footage, physical evidence found by the police, and the testimony of numerous individuals. Mr. Barton did not call 911 immediately after finding Miss Gladou in the bathtub. Instead, there was evidence that he sought to erase his link to the scene by attempting to clean the bathroom, rearranging the bedding, putting his belongings in his van, checking out of the hotel room, and that he attempted to conceal and destroy evidence by throwing the bloody towel he had used to wipe Miss Gladoux's blood from his feet and the bathroom floor into a garbage can in the parking lot of the hotel. He also concocted and fabricated multiple stories and excuses. After checking out of the hotel room, he told the hotel clerk that he had forgotten something in the room in order to get back into the hotel room. Once there, he called 911 from the hotel phone and told the 911 operator that a woman he didn't know knocked on his door the previous night and asked to use his shower, and when he woke up, he had found her covered in blood in the bathtub. He told a similar story to a work colleague. He told the police officers who attended the scene that he did not know Miss Gladou and had only seen her smoking outside the previous night. He told a completely different story on initiating a conversation with an undercover officer, telling him that he had rented out his hotel to some swampers, movers, and slept in his truck the previous night. At trial, Mr. Barton admitted to these lies, claiming, "I lied, but I'm not a liar." The potential significance of this after-the-fact conduct is palpable, and there is a strong possibility that, properly instructed, it would have had a material bearing on the jury's assessment of Mr. Barton's testimony and ultimately its verdict. Instead, the jury was given contradictory and confusing directions. The trial judge correctly told the jury in his charge that post-offense conduct is like all circumstantial evidence that can be used in deciding whether the Crown has proved Mr. Barton's guilt beyond a reasonable doubt. He stated that it was up to the jury to decide what use to make of this evidence, and that they were entitled to consider the evidence of Mr. Barton's admitted lies and discarding of the evidence as after-the-fact conduct. Unfortunately, the trial judge also instructed the jury numerous times that it could not use the evidence for those very purposes. In effect, the trial judge did not leave it open to the jury to consider the impact of the after-the-fact conduct evidence, such as the admitted exculpatory lies Mr. Barton told after Miss Gladew's death, except when such evidence favored an acquittal. In this regard, the jury was told, "You cannot infer that Mr. Barton is guilty of any offense as a result of his after-the-fact conduct, but it may be used to assess his claim that Cindy Gladew's injury was an accident." This was repeated in the concluding words of this part of the charge. "You cannot use this evidence to draw any conclusion about as to which of the available offenses Mr. Barton may be guilty of." The jury was thus precluded from using Mr. Barton's post-offense conduct to question his credibility, or as a means by which to draw any conclusions of guilt. The final instruction the jury was given with regard to after-the-fact conduct evidence was wrong in law and effectively usurped the jury's fact-finding function. Mr. Barton argues that although this particular portion of the charge may have been ambiguous or incomplete, the jury was given correct and complete instructions elsewhere. In our view, the earlier instructions do not mitigate the seriousness of these errors. Quite the opposite. Contradictory instructions do not clarify, they confuse. Taken as a whole, the result was a charge on post-offense conduct so unnecessarily confusing that it constituted an error of law. Juries, although expected to apply common sense, are above all expected to follow the instructions given by the trial judge. Where those instructions are confusing and contradictory, there is no roadmap for common sense to follow. We cannot accept Mr. Barton's submission that these errors are unlikely to have affected the outcome of the trial. The jury was told that it could not use the extensive post-offense conduct evidence to find Mr. Barton guilty of any offense. This erroneous instruction undermined the jurors' ability to properly decide whether Mr. Barton's narrative was credible. The error was compounded by the failure to indicate to the jury that after-the-fact conduct evidence may be used at a general level to impugn the accused's personal credibility. Given the inability of a deceased to provide her testimony, the jury heard only Mr. Barton's narrative of events, making the jury's assessment of Mr. Barton's overall credibility critical to its deliberations on both murder and manslaughter. There can be no doubt that these errors meet the test in Graveline and necessitate a new trial on both murder and manslaughter. After-the-fact conduct evidence was an important part of the Crown case in attempting to undermine Mr. Barton's credibility as a whole and his narrative that Miss Gladew's death was an accident to the murder charge. In fact, after-the-fact conduct evidence was critically linked to the jury's ability to evaluate Mr. Barton's entire testimony and his credibility in connection with both murder and manslaughter. Because the assessment of Mr. Barton's credibility was crucial to the outcome of the trial, this error had a material bearing on the jury's deliberations as a whole. Mr. Barton raised two procedural arguments that he says should preclude a retrial on this basis. First, he argues that the Crown's failure to object to this portion of the charge should prevent this court from dealing with this issue. Second, he submits that the Court of Appeal improperly raised this as a new issue on appeal and did not afford the accused the opportunity to provide written submissions. We disagree. The fact that the Crown did not specifically object, and indeed suggested some of the language to this position of the charge, is not determinative of the existence of procedural unfairness. The practice of providing written drafts of the charge to counsel, or incorporating suggestions from counsel, does not render a jury charge immune to appeal. Suggestions by counsel are just that, suggestions. It remains the responsibility of the trial judge to provide the jury with instructions that are coherent and understandable. It is true that the Crown did not identify after-the-fact conduct as one of its grounds of appeal when it filed its notice of appeal after Mr. Barton's acquittal. The Court of Appeal identified these errors to the parties as concerns at the outset of the 2-day oral appeal hearing. Both parties were then asked to make oral submissions on the effect of the after-the-fact conduct portions of the charge. Mr. Barton argues that this violated the court's duty of procedural fairness according to the guidelines set out in the Queen and Mian. In our view, however, this is the very type of case this court envisioned in Mian, and the procedure followed was well within the guidelines set out in that decision. In Mian, this court concluded that an appellate court's discretion to raise new issues on its own motion should be exercised sparingly and only when failing to do so would risk an injustice, including where there is good reason to believe that the result would realistically have differed had the error not been made. The court sought to balance the concern that appellate courts remain and are seen to remain impartial, alongside the court's role in ensuring that justice is done. There was a series of glaring, serious errors in a critical part of the jury charge, which had a material bearing on the verdicts in this case. As such, appellate intervention was clearly justified. Failure to intervene would have risked an injustice. We are satisfied that the appropriate balance was struck in this case, and that this is one of the rare cases in which a provincial appellate court was entitled and even required to raise an issue of its own motion. As a result, in our respectful view, the Court of Appeal properly raised after-the-fact conduct as a new issue. We are persuaded that the Court of Appeal gave counsel fair notice and sufficient opportunity to make submissions. While Mian set out broad procedural guidelines to ensure that raising a new issue of sufficient importance does not prejudice either side, it did not set down any specific procedures for providing notice and receiving responses from the parties on new issues. Rather, the guidance provided in Mian is, of necessity, flexible. The court suggested that the steps taken should be practical and will vary depending on the context and the circumstances in a given case. Mian explicitly recognized that appellate courts were best positioned to determine the appropriate procedure for responses to new issues on a case-by-case basis, and indicated that it will often be possible for appellate courts to ensure procedural fairness by adjusting to the course of the appellate process. These broad guidelines strike a balance between ensuring that parties are fully aware of new issues and can adequately respond to them, and giving appellate bodies the flexibility to raise critical issues when and as they arise. Allowing an appellate court the flexibility and discretion to adapt its procedure was recently confirmed by this court in the Queen and Suitor, where the Alberta Court of Appeal had raised a new issue during the hearing. The parties were given notice and an opportunity to respond. Mr. Suitor appealed on the basis that there should have been more of a notice and a chance to make further written and oral submissions. This court rejected the argument, stating that it had already explicitly rejected an approach that would require strict procedural standards to be followed in Mian. As such, a formalistic approach would fail to recognize that the issue may arise in different circumstances in different cases. The procedural process in Suitor closely parallels this case. The panel raised the issue of after-the-fact conduct on the first day of the oral hearing. Although the hearing was initially scheduled for a single day, it was extended to 2 full days so that both parties could make submissions. Initially, the parties were told that they would be afforded the opportunity to provide written submissions, but by the end of the second day, they were told that their answers in oral argument had been sufficient. These procedural decisions by the Court of Appeal were well within the flexible guidance afforded to appellate panels by this court in Mian and affirmed in Suitor. Notably, counsel for Mr. Barton did not argue, either at the Court of Appeal or in this court, that his submissions would have been materially different given more notice. Nor did he provide written submissions when invited by the Court of Appeal. We have no doubt that adequate procedural fairness was afforded to the parties here, who were given sufficient notice and adequate opportunity to make submissions. For all these reasons, there should be a new trial on both murder and manslaughter. We would accordingly dismiss the appeal.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.